event with Aaron Cruz, the Chief Data Analytics Officer at Littler Mendelson, the world's largest labor and employment firm. Aaron will be talking about the evolution of the modern lawyer, how artificial intelligence is transforming law. And I am so thrilled that we are having this conversation because as I meet with alumni, colleagues, and members of the legal community around the state and across the nation, I am constantly asked about artificial intelligence and how it will transform the practice of law. Sometimes people are very afraid. Will lawyers be replaced by robots or algorithms? Other times people are very excited about the ways this could transform our approach to problems and the sophistication of the legal services we can provide. And indeed, disruptive technologies like artificial intelligence are causing us to change and rethink the way we do things here at UF Law and the ways that lawyers provide services now, and certainly the ways they will provide services in the years to come. And this is the very new future. Algorithms will affect the services we provide. The legal marketplace will be quite different 10 years from now, if not 5 years from now. This is why I'm so looking forward to Aaron's talk. And I am proud that UF Law is at the forefront of these issues. Here at UF Law, we seek to leverage our existing assets, which are our alumni base, our national reputation and influence, and our amazing faculty. And we also seek to acquire new assets, leading professors and friends from around the country, new technologies, new infrastructure, so that we can take UF Law to the next level, ensuring that all of you, the next generation of lawyers, will be able to adapt to technological and other change, and even more so, be the leaders of that change. And so we are so committed to promoting innovation and information technology through our International Center for Automated Information Research, which is also known as ICARE, and its EDiscovery project, both of which are led by Professor Bill Hamilton. This is just one of the distinguished events that Bill puts together. And I thank you so much for your tireless work in organizing this event and for bringing such distinguished scholars and practitioners to our campus. And although Bill will provide a much more detailed introduction, I would like to end by thanking Aaron Cruz. We share a mutual friend who is also a partner at Littler Mendelson. And when I called her up and said, "Hey, do you know this Aaron Cruz guy?" my friend Natalie Pierce said, "He is amazing. Your students will love him." Thank you for being here today, for bringing your expertise to us, and thanks to all of you for joining this important conversation. I will now turn things over to Bill. Thank you.
Thank you very much, Dean Rosenberry, and we very much appreciate your leadership in this endeavor and in other endeavors. Aaron, welcome to University of Florida College of Law. It's nice to have you here. We have a very distinguished presenter for our Spring 2018 eDiscovery Distinguished Speaker presentation. Aaron graduated from law school in 2004, and from there he went to work as a trial attorney, doing trade secrets work in a mid-sized firm out on the West Coast where he excelled. He excelled so much that he was recruited by Littler as a trial attorney to do essentially trade secrets work. And if you know trade secrets work, it's exciting stuff. I was proud to have done a lot of that myself in my litigation career. And the nice thing about that is you get to be the plaintiff instead of always being the defendant. And that's an exciting moment. And Aaron excelled at that and was a brilliant attorney, but it was a transition point for him. During that work, he became and had to become a bit of a specialist in electronic technology, simply because that's where the information was that was allegedly being purloined by the bad guys in the litigation he was facing. So that led him to be self-taught, as many of us have become self-taught in technology and electronic discovery, to look at data on computers, on file systems, where it's located, how to collect it, how to determine who looked at it and when. This led him to develop a flourishing reputation both within Littler and both in the e-discovery world as a thought leader. So Littler basically said, well, we had this wonderful talent, let's put him in charge of e-discovery for the firm. And with some nudging, he accepted that role and did that for 3 years, leading the nation's largest employment firm and doing exciting e-discovery work. Then something interesting happened. It turned out that one of his significant clients was a company that we all know about, a small little operation called Walmart. And Walmart said, you know, we've got thousands of pieces of investigation and litigation, and e-discovery is all over the place now. Come in and help us organize our e-discovery operations. And he did accept that, again, with nudging from his friends and partners at Littler. Law firms love that when their partners go back and forth to clients. We always encourage that. It's great productivity. And at Walmart, he revolutionized the practice of e-discovery for corporations. He built the practice at Walmart from merely 5 attorneys when he arrived to 70 attorneys doing full-on forensic, doing full-on e-discovery processing and data analysis, and basically became the largest e-discovery firm, if you will, in the nation doing e-discovery work. From there, there's more. It's like a late-night commercial, but wait. From there, he goes back to Littler and becomes Littler's Chief Data Analytics Officer, doing really exciting things. And what he's doing now is he's applying the principles of machine learning and data analytics to figuring out how that firm can run better, how they can serve their clients better, how they can advance the cause of their clients, and also how the firm can prosper. So with that introduction, I'd like to present to you Mr. Aaron Cruz. It's a real honor. Welcome, Aaron.
Thank you. Thanks for having me. That was a very kind intro. So a couple of little points, only because I don't want to steal anybody's thunder. So my mentor, Paul Wiener, is actually the head of the firm's e-discovery group. I was his number 2. I was lucky to learn from him and sort of help run that. And my team at Walmart was between the directs and the indirects, sort of everybody who was involved in the e-discovery endeavor. Lawyers, paralegals, paratechnicals, and true technical people. So it was a real sort of mixed team, which is kind of how this stuff tends to work a little bit. In fact, I think a team of 70 lawyers probably would have made a mess out of it because you actually need some technical people who know what they're doing occasionally to be able to help. So, but with that, thank you very much for having me. This is a real honor. I've talked to a couple of you today at various points in time, so if you've already seen me, you'll already know this. I'm fidgety and I walk around up here. If I do that and it starts to annoy you, just let me know. I might ignore you, but please let me know. Also, if you have questions or there's something I say that you want to talk about or dig deeper into, please don't even raise your hand. Just shout it out. This is better when it's interactive. It's slightly more fun for me and for you. So with that, so here's actually kind of interesting, right? Before I jump into the panel, as I was sitting here kind of walking around getting ready to start this, I got an email from the head of my firm. I actually report to a guy named Tom Bender, who's one of the 2 managing partners of the firm. And Tom sends me this email with an article attached. And the article says, AI roundly beats lawyers on contract review in a fraction of the time. So there was just basically a head-to-head contest that was done. It was 20 lawyers from some of the highest-ranked firms in the world against LawGeek's AI, and they were analyzing non-disclosure agreements to look for potential risks that are in the agreements. The highest scoring attorney in it scored 94%, which is also the same score that the AI had. It tied. The lowest performing attorney scored 67%. That guy got a D. And the AI was 94. So the AI got an A, right? The best performing attorney tied the AI, and everybody else did worse. Right, so that's kind of the sort of stuff that we're talking about today, right? But that's a real world example that I didn't even know about it. That was literally just hit my inbox as I was climbing up here. So a little bit of how we're going to do this, right? So I'm going to give you a little bit of background on kind of where we are, where we've been, and then where we're going, if that makes any sense. So thinking about this a little bit, right? Evolution of legal innovation. One of my partners, Scott Reckshoffen, built this slide, and I love it because I think it's a really good walkthrough of sort of how things have happened. So 1900 to 1960, right? Rotary telephones, manual typewriters, carbon paper. This is how we practice law, right? Unfortunately, there's still law offices around the country where it's not that different from that. It's okay. 1960 to 1980, right? Telephone keypads, electronic typewriters. I've never even seen one of those. Voicemail, and actually that means like on a tape that you like flipped or something. I don't know, I've seen them in movies. I'm sure you have too. 1980 to 1990, personal computing, right? That's actually ridiculous, right? 1990, this is like around the time I think a lot of you were being born, right? And personal computers, actually people had them. Ridiculous. Online legal research, what? Yeah, people used to do that in books. How do you think that went? Ooh. And word processing, right? By the way, before word processing, when you screwed up, you either got whiteout or you just started over. 1990 to 2000, wide area networks, email, internet. So this is actually like functional backbone, right? Modern information society, so to speak. 1990, this is your life, right? 2000 to 2010, smartphones, websites and social media, e-billing, right? And then today, right? So in the last 7 years, tablet computers, cloud computing, artificial intelligence, legal research, process engineering, robotic process automation, data analytics. Little stuff. Small period of time. So the point of all of this is if you watch how this goes, technology is getting faster, there's more of it coming, and it's finally starting to penetrate into legal. Because, and this is like one of my examples. Anybody know what this is? Can you guess? And it's not the inside of a starship. Yeah, it's a modern operating theater, right? So that's a modern operating theater inside of a state-of-the-art hospital today. I want to play a little thought experiment with you, okay? Anybody have any idea who this guy is? So this gentleman, he was a major during the Civil War, fought for the Union. He invented the process of battlefield triage. And basically, before this gentleman came along, if you got shot on the battlefield, you died. This guy figured out how to evac, as a doctor, figured out how to evac wounded personnel off the battlefield, and survival rates went way, way up. If we took this person and we moved him forward 150 years-ish to today, he was state-of-the-art doctor in his day. If you put him in that medical operating theater, his head would explode. He would have to go back to first grade probably. In fact, the only part of his medical training that would be useful today is maybe the human anatomy part of it. Everything else he'd have to relearn, right? But let's compare that to, anybody know what this is? Let's take another individual. Bring him forward 150 years. Maybe you know this guy. Lawyer, right? If I brought him forward 150 years and I stuck him in that office, he'd be right at home. You'd have to teach him how to use a laptop, how to use a mobile phone, how to enter his time into an e-billing system. Away he goes, practicing law, no problem. Which is a huge problem, right? Like, there's nobody who should look at that and be like, yeah, that's good. Because innovation is literally changing every other industry across our economy. Every single one. Look at all of them. Accounting, journalism, right? I mean, algorithms write many of the news articles that you're reading in your feed. They're not written by people. People don't even look at them, right? Particularly anything that's about the stock market, that's like reporting, it's automated. Medicine, insurance, travel, banking. We're going to talk about banking a little bit because I think banking is actually a model for where the law is going in an interesting way. Also something that I stole from Scott Reckshoffen, so I'm giving him credit before I'm going to steal all of his ideas. But that's what we do in the law, right? We steal ostentatiously, and we call it precedent. None of these companies existed 20 years ago, right? They were all startups to the extent that they were there. Google, right? Startup. Netflix, nope. Instagram, nope, right? All of this, they're taking modern technology and they're leveraging it into what were then existing businesses, but it's completely changed how they function. Amara's Law, anybody familiar with this? We tend to overestimate the effect of technology in the short run, by the way, the thing that has people panicked about AI, it's because they're overestimating what it's going to do in the short run, right? Then we tend to underestimate its effect in the long run. Because in the long run, technology tends to be beneficial, except when it kills us, but other than that, beneficial. And that brings us to this. Anybody familiar with this concept? Fourth Industrial Revolution? So here's what's interesting. This is actually incorrect, in my opinion. And there are people who will argue with me, but if you look at this spot where it says computer and automation and cyber-physical systems, we're in both of those right now. Those are happening together. The computer and automation piece is like here, and the physical systems piece is like here, but they're both out of the gate, and we're doing them both at the same time. And that's really, really important because of what it means for everything we're doing as a society. And law, we are inextricably intertwined to the functioning of this society. The phrase "kill all the lawyers," right? The reason that that's written in Shakespeare is because if you want to get away with something, if you want to take over, if you want to be a tyrant, you kill all the lawyers. It's a misunderstood quote. So here are some things that are going on, right? This is today. This is real. This is the stuff Natalie Pierce talks about. Robotics and artificial intelligence are predicted to have $258 billion in revenue by 2020. Oh my God, by 2020, that's 2 years from now. People write 2020 and it's like, oh, no, it's like 18 months. Be there in a minute. $1 trillion of revenue by 2025, and shortly thereafter, it's anticipated to become the largest global industry in the world. Let that sink in for a minute. Building and servicing and dealing with robots is anticipated to be the largest industry in the world. But here's where we overreact. 48% of surveyed experts envision a future in which robots and digital assistants have displaced significant numbers of both blue and white-collar workers, increasing unemployment. I work for the largest labor and employment law firm in the world. We got kind of a vested interest in this issue, right? But here's the deal. Y'all do too. And here's why. We're at a place right now where there is going to be a displacement. There are a bunch of jobs that exist today that are no longer going to exist. Short-haul truckers, there are like 800,000 of them in the United States. Those people are all about to be out of jobs because short-haul trucking is the perfect thing for an autonomous vehicle to do. What do we do with those people, right? If you're a 20-year-old short-haul trucker, it's probably not a huge deal if that job goes away. We can retrain you. We can reskill you. You barely have any skills as it is. If you're a 60-year-old short-haul trucker, you're kind of worried by this, but you're kind of looking at retirement anyway. Maybe you can last long enough to get there. If you're a 39 to 40-year-old, I don't know, wearing a blue suit and gray pants and short-haul trucker, that's got to scare you to death because you've built your professional career doing something, and that's gone. And what do we do for those people as a society? How do we start to retrain and reskill them before they're out of jobs so that they can take what I'm calling next collar jobs, right? Not blue collar, not white collar, next collar. Because there are a bunch of white collar jobs that are about to disappear too. If you're a pathologist or a radiologist, guess what jobs in medicine are about to be automated? Because guess what computers do? They recognize patterns super, super well. As long as they've been taught the pattern, they'll recognize it. What does that mean for radiologists and like pathologists and whatever? One of two things. Either we have fewer of them, or anybody ever been to the Midwest? Anybody ever lived there? Who's from the Midwest? One of you has to be. There you go. If you don't live in a major city, how easy is it to get to a hospital with like a really good radiologist or a really good oncologist? Hours away, right? But what if those things can be read in a hospital and you have one radiologist sitting someplace who's supporting 10 hospitals? What does that do now? I have a 2-year-old son, and I get choked up when I talk about it. He burned himself when he was a baby, and we were living in Northwest Arkansas, and he grabbed a hold of a fire, it was a gas fireplace. It has the thing down the middle that's throwing flame, and he walked up to it and grabbed it. Yeah, I wonder if he's smart as well. Turns out he is. But he burned himself really, really bad, like 3rd-degree burns. It was awful. And my wife had to get in an ambulance with him and go 3.5 hours to the Children's Hospital in Little Rock because that's where there was a specialist who could deal with that. Imagine if that weren't necessary. That's an option, right? That's what we're talking about. So, problem though. How do we get from here, displacement, to there, where those next collar jobs are identified and people are trained for them and people can take them? How do we do that? Well, one of the things lawyers do, besides litigate and push paper at each other and yell, "I'll sue you," we help make policy. We help have conversations around this. We help legislate. We litigate and help define what that legislation meant, right? This is the conversation we need to have. This is the conversation of our time. Here's the scary part. No one's having it. Nobody. The federal government isn't talking about this at any kind of level that makes any sense. Your state legislatures not talking about it. So how do we have the conversation? We got to push them. But this is the conversation we have to have because here's the choice. Here's the choice. Anybody know what that thing on the left is? Who said that? Yeah, what is it? It's a Hooverville. So during the Great Depression, huge chunk of the population out of work. People lost houses and farms and whatever. And they moved to the cities, and they had no jobs because there were no jobs to be had. And they had no money, and so they built these shanty towns in the middle and on the edges of cities. And little kids grew up there, and it looked like a slum in Rio or the worst parts of, pick your major city in a developing country. And that was here in the United States. That's Hoovervilles. That's one choice. I prefer the other side. It's more colorful. It's more fun. Flying cars. Who doesn't want that? Jetsons, right? Humans augmented by technology. I call it human computation. It's the fusion of what humans do really, really well with what computers do really, really well. So we can up-level what we all do every day. So here's the cool part. You're thinking, God, are lawyers going, am I studying something that's about to disappear? If AI is better than lawyers doing contract review, why am I spending money here? There's a bunch of stuff that this will not be doing. This will not be doing, new business development, meeting with clients. Getting drinks with a robot is not fun. They will always drink you under the table. Trust me, I've tried. Developing winning case strategy, right? They're not good at it. And every time I say that, in fact, last night at dinner, I had dinner with some of the faculty here last night. They were kind enough to sit and listen to me talk, which I'm noticed none of them are here, so clearly they got enough of that last night. I had several of them say, well, what about the AI that just beat, the best Go player in the world? Everybody's familiar with Go? It's the most complicated game on Earth. Apparently there are more available moves in Go than there are atoms in the entire universe. Let that sink in for a minute. Yeah, I can't even wrap my head around that math, and I do math pretty well. They were like, well, what about that? Go's a really strategic game. It is, but it's pattern recognition, right? That's what it's doing. The same thing when Deep Blue beat Garry Kasparov at chess, right? What about that? That's strategic. Chess is a really strategic game. It is, but that's pattern recognition. It's playing the odds of what's going to be the best move. Here's a fun fact. So the Deep Blue algorithm that beat Garry Kasparov, who at the time was the best chess player in the world, if you took that algorithm and had my 2-year-old play checkers against it, my 2-year-old would win, and he doesn't know checkers. Similarly, if you ask that Deep Go algorithm to drive a car or tell you what color blue is, or nope, can't do it. because algorithms are very, very specific in what they're able to do. They're a tool. And they only do what they've been trained to do, and it's pretty narrow. So like the fact that Google spent a lot of time annotating YouTube videos so it could teach its AI to identify cats in video is cool. But ask it to identify elephants, and the answer is no. Taking depositions, not going to automate that. Negotiating settlements and mediation, arguing motions in court. Your Honor, I believe my client, that's not going to go anyplace. Negotiating collective bargaining agreements, providing subject matter expertise on cutting-edge issues and novel questions of law. That one's never going to be replaced. You know why? Because computers can only tell you what they've been taught. The stuff that they haven't been taught yet doesn't exist for them. Whereas a human can look at something that's developing and say, like, hey, we're about to displace 800,000 short-haul truckers and they need new jobs. What do we do with that? And by the way, if what we're talking about is an on-demand economy, where people essentially act more as independent contractors more often, and you're going to see those numbers go up, which is probable, what do we do as a society around social safety net, things like retirement, paid time off, sick leave? What do we do? Ask an algorithm, they're not going to give you an answer. Put a group of smart people in the room when they stop fighting, throwing things at each other, they may come up with an answer. And that's where you all come in. So, no robot lawyers yet. But artificial intelligence will dramatically impact many of the tasks that are currently being done by lawyers. How many of you in this room have work experience? You've worked in a law firm of some kind. Cool. So, what are you doing day to day? Yeah, you. Yeah, you.
Like here?
No. What are you doing day to day at the firm where you work?
Research.
Research. Wow, that's weird. Look at that first one. What? You mean an algorithm can do that for me? Yeah.
I definitely know it can. Yeah.
Mm-hmm. Yeah, and it does.
Westlaw starts to know what you're searching and shows you things. It's interesting.
So theirs is cool tech. Some of these take it considerably farther. Like the ability to zero in on the case precedent that has the most impact on the arguments you are specifically making. Like the ability to tell you which cases you missed or the other side cited incorrectly. That's pretty cool, right? Imagine doing that in books. Yuck. Books. Contract review, diligence, and management. We just talked about that at the opening, right? Because it's pattern recognition. Verifying legal strategy using analytics, right? We can actually start to run numbers on how likely an argument is to sway a judge. Because we can say, how many times has that judge seen that argument? How many times has that judge ruled on that argument? How have they ruled? And what do we do to tweak our argument to put us in that seam? That's pretty cool. Here's the other thing it can do. This one's very cool. Drafting basic pleadings, discovery requests, and responses. So you can take today, I can get a complaint, I can scan it, I can feed it into this tech, and in about 2 minutes, plus minus, I get what I would call a very, very good first draft of an answer with affirmative defenses, draft ROGs, draft request for production, right, draft discovery, that I can then spin around and give to an associate and say, hey, spruce this up, make this awesome, you got an hour instead of 12, right? Which you're about to learn, being a first-year lawyer, second-year lawyer, third-year lawyer, you're going to do a lot of drafting nonsense, right? It's not substantive, it's not strategic, it's usually not that fun. And you're doing that so that you can do the more substantive strategic stuff. Well, if I can automate that, let's just move you to the substantive and strategic. The stuff that adds value, not as make work, do work. The high-level thinking stuff that you came here to do. That's cool. You should be excited about that, right? It's like I just told you, like, hey, you don't have to dig in the mine anymore. You can come hang out. Come to the light. Review core filings for accuracy, persuasiveness of arguments, likelihood of prevailing before a specific judge. This one's cool. If you have the opportunity, you should totally use it on your writing assignments because it does something really neat. It will grade your brief and improve it. It'll take your brief and be like, hey, here are the arguments you made. And it grades them, A, B, C, D. I don't think it gives people Fs because that would be like rude or whatever for a paying customer. And then it makes suggestions on pieces of argument that you should make or citations that you should add. Think about what that does for you, though. It doesn't just improve the brief. It makes you better at argument and a better writer. That's astounding. As a kid, I couldn't spell at all, right? Like, couldn't spell, mostly because I was lazy and said somebody would do it for me. Luckily, somebody invented technology that did that, or my mom would have been right. But now I can spell. You know why I can spell as a grown-up? Because for my entire functional life, I've had spell check. And so, you know, I saw believe changed enough times that I believe I now know how to spell believe. It's pretty cool. Answering basic questions. Anybody use chatbots right now? Alexa, Siri, blah, blah, blah. Alexa, what's the temperature outside? Alexa, buy me Whole Foods. Oops, sorry, Jeff Bezos. These are very cool. You are probably interacting with them a lot and a lot more often than you know. If you're online and you see the little pop-up box that's like, would you like to talk in real time? We can answer your questions. And it looks like a person. It's not. It's a bot. And they're really, really good at basic questions. And when it gets above its head, it routes you to a person. That's coming for the law as well, where I can have a database, an expert system that gives sort of decision tree kind of answers to clients, bop, 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 bop. And when it runs into the end of the program, it takes it and it shunts that client and that question to one of the subject matter experts in my firm. Imagine how sticky a relationship that creates with the client. Do it on a subscription model, doesn't cost you a lot, designated cost, boom, 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 boom. And when you get to a question that we haven't already answered or is too complicated and you need a human to actually jump in and dig, bang, pops out in a really efficient way. We already have the information we need to start answering the question. That's cool. This expertise automation is the backside of the chatbot piece. It's what makes the chatbot run. It's the thing I was just talking about, right? It's building out those basic building blocks. How do I know if this person is an independent contractor? Well, what state are you in? California. Okay, bang, here are the elements. Bop, 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 bop. I've got 3, but not this one. What does that mean? Ooh, end of program, subject matter expert. That's pretty cool. As Professor Hamilton likes to say, EDiscovery is the beachhead by which artificial intelligence and machine learning have entered the law, right? And it's now sort of, it's going to perfuse through, right? But what you're seeing in the EDiscovery space is actually tremendous because, this is my own personal sort of view of the world, we're about to see a day, so back step. Okay, cool. EDiscovery, and discovery in general, is the single most expensive portion of any piece of litigation. It's immediately followed by a long trial, but it outstrips everything else in the entire case. It's most of what lawyers who litigate do. And it's very, very expensive. And the most expensive part of discovery is humans looking at documents. And most of the documents that most humans are looking at are complete and utter garbage. Irrelevant, they don't matter, nobody should be spending time or money on them, and so every dollar that's spent doing that is a wasted dollar. But what did I say earlier about what machines do really, really well? Pattern recognition. And identifying relevant information. By the way, I whispered pattern recognition, just so you know. And the process of identifying relevant information in documents is really pattern recognition around phrases used, ideas or concepts, and conjuncted words, right? Words smashed together to mean things. And so once you train something, hey, here's what I'm interested in, starts getting really good at teasing that out. There are some things we can do to create algorithms that look for bias to make sure we're not like missing stuff because we're too narrow a focus and whatever. But we can actually build machines that do this. And here's my prediction. In the next 5 years, we will be in a place where the documents that humans are actually putting eyes on are about 5% of what's happening in an average case today. Yes?
I recently tried a will contest and was able to get the will thrown out because the different portions of the will were not in sync with each other. They were contradictory. Now, am I going to get to the point that the next time I can put in evidence what the computer told me? With the inconsistent statements in the will?
Yeah, absolutely. I mean, you, at least presumably right now, you would need, that's not going to be self-authenticating yet, although if it was collected in a forensically sound manner, it would be self-authenticating under the new federal rules. Ooh, weird loophole. I don't know that anybody thought about that when they were doing it, but short answer is yes. So you should be able to say, I ran it through an algorithm, and the algorithm looked at XYZ, whatever it was, the metadata, the content, the concepts that are there, and here is the analysis, and then you have somebody either testify about what that means or not. I mean, it's very similar to what happens in like trade secret litigation or other places where you're doing a forensic analysis or you've done a data analytic exercise looking at like disparate treatment in pay or something like that. And yeah, literally the analysis is what people are testifying about.
Then how does the judge find it's not inconsistent if the algorithm told her or him that it was?
I mean, it depends on what's on the other side, right? And it depends what the algorithm was looking at. So remember, so the thing about algorithms, it's garbage in, garbage out. So if I give it bad data, it's going to produce garbage, right? It's if I give it good, complete data that what comes out of it's useful. So that would probably be the point of attack. But theoretically, so I'll give you an idea. If you could go to the other side in that will contest, and you said, look, you're filing a suit, or you want to try and enforce this will, or whatever, whichever side of the V you were on that one, right? And you said, look, here's my analysis that shows that that thing's garbage. And if you litigate this, this is what I'm going to attach to either my complaint or my answer. I'm going to make you pay all of my costs because this is not brought in good faith, because I'm telling you up front. That's probably a pretty powerful way of getting that thing done, just guessing. That thing probably never sees a courtroom. You probably never ask a judge to look at that. I had a case years ago when I was practicing where a woman accused our client of terminating her because she was pregnant. And she had a printout of an email that was allegedly sent to her that was like, Stacy, you've been the best associate ever, and we've made millions of dollars off you, but we're firing you because you're pregnant, periods. P.S., I'm awesome. Best, the boss. It's like, wow, that's so weird. Who would send an email like that? I mean, people send stupid things in email, but not like that. And when we went and looked for it, we couldn't find it electronically anywhere. And when we were staring at it, what we actually noticed is that the person who wrote the email didn't know the difference between a semicolon and a comma. And so everywhere you would put a comma in the English language, there was a semicolon. And it was like, whew, that's a weird quirk. And so we went back and we looked at the plaintiff's work history, all the stuff she'd ever drafted. Man, that thing is there in every single one of them. Every single one of them. And so I just took a big stack of those, and I walked up to her lawyer and I said, your client wrote that. Here's my proof. Call me when you're done. And he didn't call me. He just called me to let me know that he had dismissed the case with prejudice and he was out. Same thing. Same concept. Giving people evidence up front is a really powerful way to resolve disputes because you're not having a dispute anymore. It's only when the facts really conflict or people don't know the facts that we're fighting. So, here's what I'm calling it. I'm calling it human computation, aka Bionic Lawyers. This is y'all. The fusion of what humans do really, really well, that creative, that strategic, with what machines do really, really well. Brute force crunching through data. They never get tired. They never get cranky. They never need sleep. They synthesize data so that a human can take that data and make decisions. This is what we should do with this case. Here's the argument we should make. we need to get rid of this because we're dead. We should absolutely try this if they don't give us exactly what we want because we're righteous. That's cool. So data analytics. Anybody familiar with the term? It's one of the ways we synthesize data. So we can take huge amounts of data, right? And we can run it through an algorithm and ask the algorithm to help us understand the data, right? And we can do that in a whole bunch of different ways. But everybody familiar with kind of the Me Too movement, that whole thing going on? Pay equity? Anybody heard this phrase? Yeah? I got 10, so I'm going to go fast. Pay equity is the idea that men and women should get paid the same for doing the same stuff, right? And it's all over the news right now. So one of the things we've been looking at my firm is how do we talk about these pay equity issues in a way that people can understand and do something with. So that thing on the screen right there, that is a pay equity analysis right there. Raise your hand if you know what that means. If you said, Aaron, I need a pay equity analysis, and I gave you that, you're going to be super stoked? No. Thanks. That's great. Right? You have any chance of operationalizing that? Nope. If you were, I don't know, like a 5th level lawyer, in-house counsel someplace, you're going to take that to the general counsel and be like, hey, I got it. No, it's incomprehensible. But with data analytics and data visualizations, we can engage in what I call data storytelling. That spreadsheet, that's being displayed right there. Got drop-down menus that I can change in real time to account for things that may affect pay. Things like, I don't know, tenure, rating, education. If you look on the side right here, I can tell you in what states you have employees that are represented in the data, and in what states your pay disparity is okay, meaning if there's a difference, it's not statistically significant. And what states where you may have a potential problem. We thought long and hard about how to display that information. We thought green, good, red, bad. Don't know if that resonates with anybody, but that's what we did. This is way easier to understand, way easier to operationalize, way easier to take to your general counsel and say, hey, we have a problem in Pennsylvania? Yeah, we got a problem in Pennsylvania. We should go chat about that. We should dig into that and figure out what's going on. We should call our lawyers and have a discussion about it. So here's how this starts to play out. With filters applied, here's what I can tell you. Looking at mid-level officials within a particular organization, we got a problem. We got to go dig into what's driving compensation for both men and women. And at the end of the day, it may be permissible, but that's red flag, not unintentional, right? Versus these where, we can probably leave these alone, or if we are going to look at them, we'll get to them later. That's really cool. I mean, think about that. That versus that. It's a wild conversation. Here's another one that you can do with this. Drive this home even more. Imagine for a second that you are in front of a jury. Now, I jokingly said this morning, the same joke I'm going to tell again, so if you already heard it, I apologize, but it's got some truth to it. Juries are a vaunted thing in this country, and there's a reason for that. But if you look at the day-to-day, what actually happened, it's 12 people who either wanted to be on the jury or weren't smart enough to get out of jury duty, which is not a high bar. And you need to explain to those people, right, who either have an agenda, and that's not true for everybody, obviously, it's a total generalization, but for a big chunk, it's true. And you need to explain to those people who either have an agenda or weren't really paying attention when the questionnaire went out, hey, my client's right. If I give them this and say, Mr. Hamilton, will you please tell the ladies and gentlemen of the jury what that means? Night-night time. Yes, ma'am.
So if there's a dispute over something that was created by artificial intelligence, and you're in front of a jury, how does that hold up because artificial can't testify in a courtroom or in certain circumstances where, I don't know, just
Yeah, so now you're into expert testimony and sort of a Kelly Fry kind of test, right? So it would be, you would have an evidentiary hearing ahead of time. There'd have to be a challenge to it. And then depending on the objection, I would argue that that had to be made in a motion in limine, but whatever. Let's say you do it in real time, so the court would take you, basically dismiss the jury. You'd have an argument right there about whether or not that was admissible. You've been to evidence, taken evidence, yeah? Okay, you're in evidence. So you go through the rules of evidence, and they're saying, nope, it doesn't fit the rule of evidence. It's out, it's out, it's out. And you'd say, nope, it gets in like this, this, this. And that's it. And it either comes in or it doesn't.
So, but aren't most of these things machine generated?
Yes.
So, I mean, I don't know a lot, but we just learned that if it's totally machine generated, it wouldn't be admissible.
I would totally disagree with you. There's all kinds of evidence. It's non-testimonial evidence. So, like, database data is machine generated, right? So, database data is, and it comes in all the time. I mean, argue that with your evidence professor probably, but I see and have put on machine generated, like a forensics report is machine generated evidence, and it comes in, and then you need an expert to testify about what it means and what its significance is to the jury. You're probably in that same situation here. 5 minutes. So what does this mean for the practice of law, right? So this is my big thing, access to justice. So I actually believe that the fact that the law operates fundamentally at a paper level, even today, in a digital world, has created a situation where we are pricing people out of justice. It is really, really expensive to go to court. And there are a lot of people who have valid claims who don't go because they can't afford it. And that should be really, like, we should all be very concerned about that. That's a real problem. Because the ability to get into court undergirds and have your case heard, to have your dispute settled by either a judge or a jury of your peers, right? That's what allows us to resolve differences without violence. If people are priced out of court, they will shoot at each other. The Hatfields and the McCoys were a real thing. The technology I'm talking about, if I can drive down the number of hours that lawyers have to spend doing the drudgery parts, I can drive down the price point at which lawyers can make money from cases. I can make it economically viable for a lawyer to take a case tomorrow that they wouldn't have taken today because it doesn't make economic sense. We can increase access to justice. That's huge. Quickly, here's a historical example. Everybody know what that is? It's an ATM, that's right. Invented sometime in the 1980s. When it was invented, experts predicted that ATMs would eliminate all bank branch tellers. All tellers would be gone. Y'all been in a bank recently? Lots of tellers. In fact, from 1990 to 2010, more tellers than there were the day before the ATM was invented. You know why? Because the infrastructure necessary to support the ATM drove down the price point at which you could start up and operate a bank branch. And so banks pushed them out everywhere. And they realized that counting coins and dollars is a zero-margin business. But talking to you, creating a sticky customer relationship, getting you to apply for credit cards and stuff, that's a high-margin business. And so they opened up stuff all over the place. Imagine if law firms did something similar. Quickly, 4 technologies you need to know. Blockchain, machine learning and algorithms, aka artificial intelligence, cryptocurrency, nanosensors, and the Internet of Things. I'm out of time, but what I will say is I'll hang around, and we can talk about it if you want, but spend some time reading about these, because these, in my opinion, are going to be core to your practice over the course of the next 10 years. You need to understand how they work, you need to understand what data goes into them and undergirds them, and you need to understand what comes out of them, because you are going to have disputes in your practice, and you're going to need to understand the technology in order to articulate it to a court, articulate it to a jury, or have a conversation with your client. And that's the future of law right there. Thanks, ladies and gentlemen.
Thank you very much, Aaron. We really appreciate it. Wonderful presentation. On behalf of the law school, I'd like to present you with a little token of our appreciation.
Thank you very
And
much.
welcome here. moon over at the University of Florida. Hopefully you'll show it to your friends.
Yeah, thank
Talk
you.
about
Thank
your
you very
experience here
much.
at the University of Florida.
Thank you very much. This has been an absolute pleasure. Thank you.